imagine you're watching one of those brilliant detective shows, right? Every clue, every statement, it all has to fit. But what makes something a real clue? What makes it actual proof?
That's the core question, isn't it?
Welcome to the Deep Dives. Today we're really getting into it, the fundamental principles of evidence, specifically under India's brand new law, the Bharatiya Sakshya Adhiniyam 2023, the BSA.
Exactly. And it's not just a minor update. The BSA replaces the old Indian Evidence Act from way back in 1872.
Wow, 150 years old.
Yeah, so a long time coming. And this new law brings in some really crucial changes, especially around digital evidence, which, let's face it, is everywhere now.
Definitely.
So our mission today really is to give you a kind of shortcut to understanding how courts figure out what facts matter and, maybe more importantly, how those facts can actually be proven. It's the bedrock of a fair trial.
Okay, let's dive right in then. Before proof, we need facts. What is the law? What does the BSA actually consider a fact? Seems simple, but I bet it's not.
Well, you're right. It's broader than you might think. At its core, a fact is anything you can perceive with your senses, seeing, hearing, smelling, the usual.
Okay.
But it also includes any mental condition that a person is conscious of. Think intention, knowledge, even things like goodwill or fraud.
So if I saw an accident, that's a fact. And if someone intended to do something, that intention is also a fact in the eyes of the law.
Precisely. That mental state is just as much a fact as the physical action. It's a really foundational definition.
That is broad. Okay, so you have these facts, but then there's this distinction I hear about facts in issue versus relevant facts. What's the difference there? Why does that matter so much?
It matters hugely. This is how the court filters what's actually important for the case. Facts in issue are, well, the main points of disagreement. They're the core questions the court has to answer to decide the case.
Like in a murder trial. Did person A actually cause person B's death?
Exactly. Or did they intend to? Was there provocation? Those specific disputed points are the facts in issue. The whole case revolves around proving or disproving them.
Got it. So what are relevant facts then?
Relevant facts are different. They aren't the main questions themselves, but they're connected, logically connected, to the facts in issue. They make those main facts seem more probable or maybe less probable.
So sticking with the murder example, maybe the accused had a motive.
Right, motive, or maybe they were seen near the crime scene, or their fingerprints were on the weapon, or they tried to flee afterwards. None of those directly prove they committed the murder.
But they make it look more likely. They're relevant.
Precisely. They form a logical chain leading towards or away from the fact in issue.
And here's the kicker, right? Only relevant facts are actually allowed in court. You can't just throw everything in.
That's absolutely crucial. Admissibility hinges on relevance. It keeps the trial focused, prevents wasting time on unrelated details, and ultimately aims for a fairer process. You have to show that logical connection.
Makes sense. Keeps things on track. Now, you mentioned digital evidence earlier. That feels like one of the biggest changes, adapting to how we live now. How does the BSA handle all this digital information?
It's a major overhaul. The BSA explicitly expands the definition of a document. It now clearly includes electronic records and digital records.
So emails, files on my laptop, stuff on my phone?
Yep. All of that. Information stored on smartphones, laptops, cloud servers, any communication device, it can all potentially be considered a legal document now. It references the IT Act, too, for, the technical specifics.
Okay, huge question then. What about my WhatsApp messages? Or emails, social media posts? Are they just automatically proof now?
They can be proof, yes. Powerful proof, potentially. But there are conditions, especially for admissibility. The BSA basically puts electronic records on the same level as traditional paper documents.
So you can't just dismiss it because it's digital.
Exactly. And here's something really interesting, a big shift. An electronic record that's produced from what the law calls proper custody.
Proper custody, meaning?
Meaning, essentially, it comes from where you'd naturally expect it to be, and there's no reason to suspect it's been tampered with. If you have that original electronic record, say, the actual phone with the original chat history.
Yeah.
The BSA says that can be considered primary evidence, unless, of course, its authenticity is disputed.
Wow. So having the actual phone is like having the original signed contract.
Pretty much. That's the idea. It treats the original, untampered digital source with significant weight. That's a big deal for simplifying things.
Okay, that is a big deal. But what if I don't have the original phone? What if I just have, say, a screenshot? Or a printout, or someone forwarded me the file?
Right, good question. If it's not the original source, then it's considered secondary electronic evidence. And for that to be admissible, the BSA sets out specific conditions.
Like what?
Often it involves getting a certificate, usually from a responsible person, like an official managing the system or device it came from.
Okay, a certificate. What does that have to prove?
It needs to properly identify the electronic record, describe how the copy was made, and certify key things like the device it came from was used regularly, it was operating properly, and the information itself was generated in the ordinary course of activities. It's all about establishing that the copy is reliable.
Right, proving the copy is trustworthy, even if it's not the original.
Exactly, and particularly for things like social media, WhatsApp, emails proving who actually sent it, that it hasn't been manipulated, and maintaining a clear chain of custody. That's absolutely critical.
Chain of custody, tracking where it's been.
Yes, who's had control of it to ensure it hasn't been altered along the way. Ultimately, how much weight the court gives it, its probative value, depends entirely on its authenticity, its integrity, and its overall reliability.
That makes sense. A huge step into the modern world for evidence law. Okay, so beyond digital, evidence generally falls into two main types, right? Oral and documentary.
That's the classic distinction, yes. The BSA defines evidence broadly to cover both. Oral evidence is basically statements made by witnesses in court, and that now explicitly includes statements made electronically, like video conferencing.
Okay, and documentary.
Documentary evidence covers all documents produced for the court to inspect. And as we just discussed, that now clearly includes all those electronic and digital records too.
Let's talk about oral evidence first. Can anyone just say whatever they heard someone else say, like gossip?
Generally, no. That's hearsay, and it's usually inadmissible. The fundamental rule for oral evidence is that it must be direct.
Direct, meaning?
Meaning, if a witness is testifying about something they saw, they must have seen it themselves. If they're testifying about something they heard, they must have heard it directly, first-hand knowledge.
So no, my friend told me that he saw.
Exactly, but that's the classic example of hearsay. The person who actually saw it needs to testify. There are exceptions, of course, like dying declarations or statements forming part of the same transaction, but the general principle is directness. Section 60 lays this out.
Okay, direct experience is key. Now, for documentary evidence, what's considered the gold standard? The best kind?
The best kind is always primary evidence. That's the original document itself, the actual contract, the original will.
Or the original phone with the chat history, as we said.
Precisely. That original electronic record from proper custody now falls under primary evidence too, according to Section 57. It's the most authentic source.
So what's secondary evidence then?
Secondary evidence is essentially anything other than the original document. It's considered less reliable, but it can be admitted under specific circumstances.
Like if the original is lost.
Exactly. If the original is lost or destroyed, or if the other party has it and won't produce it, or if it's a public document you can get a certified copy of. Examples include certified copies, copies made by mechanical processes like photocopying, even an oral account of a document's contents given by someone who has actually seen the original. And the BSA adds a couple more things here too, like written admissions about a document's contents or expert testimony if you're dealing with huge volumes of documents.
Okay, so primary is best, secondary is usable if you meet the conditions.
Got it.
So how does this all play out in proving a case? We hear about direct evidence and circumstantial evidence all the time. Are they different? Is one better?
They are different, and it's a really important distinction. Direct evidence goes straight to the point. It proves a fact in issue without needing the court to make any inferences or logical leaps.
Like an eyewitness saying, I saw him pull the trigger.
Exactly.
Right.
Or a clear video recording of the event, or a confession from the accused. It directly addresses that core question, that fact in issue.
Okay, so circumstantial evidence is what?
The opposite.
Not exactly the opposite, but it works differently. Circumstantial evidence doesn't directly prove the main fact in issue. Instead, it proves other facts, relevant facts, from which the main fact can then be logically inferred. Ah, okay. So it builds a picture.
Precisely. It builds a chain of circumstances. Think back to our murder example. Finding the accused's fingerprints on the weapon, proving they had a strong motive, showing they were near the scene, evidence they tried to flee. None of those individually prove murder.
But taken together.
Taken together, they can create a very strong inference of guilt.
There's that analogy, isn't there? Direct evidence is seeing the rain. Circumstantial evidence is seeing the wet ground. and people with umbrellas.
That's a perfect analogy. Both can lead you to conclude it rained, but one requires that step of inference based on the surrounding circumstances.
So is one type inherently stronger than the other in court?
Not necessarily. While direct evidence often feels more straightforward, a strong chain of circumstantial evidence can be just as powerful, sometimes even more so, especially if the direct evidence is unreliable, maybe from a questionable witness.
Yeah.
But, and this is crucial, especially in criminal cases, the courts are very strict about relying on circumstantial evidence. The Supreme Court has set clear rules. The circumstances from which you're drawing the inference must be fully established, proven beyond doubt. Those established facts must be consistent only with the hypothesis of guilt. They absolutely must exclude any reasonable possibility of innocence.
So no other explanation fits the facts.
Right. The chain of evidence must be complete. There can't be any gaps. It has to point unerringly towards the guilt of the accused and nothing else. Think of Sharad Bardichan Sarda v. State of Maharashtra, a landmark case on this.
A very high bar, then, for circumstantial evidence. Okay. Now, courts don't always need direct proof for everything, do they? Sometimes they can make assumptions, presumptions.
Yes, presumptions are a vital part of the legal process. They help make trials more efficient. A presumption is basically an inference about a fact that the court draws based on other facts that have been proven.
So it's like a legal shortcut.
In a way, yes. It's a rule of law that either allows or requires the court to assume a certain fact is true until someone proves otherwise. It can shift the burden of proof quite dramatically.
How many types are there?
The BSA, like the old Act, outlines 3 main types, clearly defined in Section 2. First, there's may presume.
May, so it's optional.
Exactly. It's a discretionary presumption, usually a fact. The court may regard a fact as proved based on other proven facts, or it can choose to ask for more direct proof. It's rebuttable if the other side can bring evidence to disprove it. A common example is presuming a 30-year-old document from proper custody is genuine. The court may presume it, but doesn't have to.
Okay, may is optional. What's next?
Next is shall presume. This one is mandatory. It's a presumption of law. If the basic facts are proven, the court it must regard the presumed fact as proved unless and until the other party disproves it.
So the burden of proof definitely shifts here.
Absolutely. A very serious example under the BSA, Section 117, relates to abetment of suicide by a married woman within 7 years of marriage. If it's shown she was subjected to cruelty by her husband or his relatives soon before her death, the court shall presume they abetted the suicide. They then have the burden to prove they didn't.
That's powerful. Okay, may shall. What's the third?
The third is conclusive proof. This is the strongest type. It's an irrebuttable presumption of law. Once the basic fact is proven, the other fact is considered conclusively established.
Conclusively, meaning?
Meaning no evidence can be offered to disprove it. Once fact A is proved, fact B is proved, period. The prime example is the legitimacy of a child born during a valid marriage, Section 116 of the BSA. If a child is born while the marriage is ongoing, that's conclusive proof the child is legitimate unless non-access between the parents can be shown. You simply can't argue against it otherwise.
Wow. So that language, may, shall, conclusive, is incredibly important. It dictates exactly how much weight the court gives that assumption and who has to prove what.
It makes all the difference in the courtroom dynamics.
Okay, so we have all this evidence, all these rules. Eventually, the court has to decide on each fact. Is it true? Is it false? Is it something else? I know there are these specific terms. Proved, disproved, not proved. How do those work?
Right. Those 3 categories cover every possibility for a fact being considered by the court. A fact is proved when, after considering all the evidence, the court either believes it exists or considers its existence so probable that a prudent, reasonable person would act on the assumption that it exists in the circumstances of the case.
So it meets the required standard of proof, like beyond reasonable doubt in criminal cases?
Exactly. That standard is part of determining if it's proved. Then you have disproved. It's basically the opposite. The court believes it doesn't exist or considers its non-existence so probable that a prudent person would act on that assumption.
Okay, proved or disproved? Seems straightforward. What's not proved?
Not proved is the crucial middle ground. A fact is not proved when it's neither proved nor disproved.
No, maybe.
Sort of. It means the evidence presented was insufficient. It didn't convince the court either way to the required standard. Maybe there wasn't enough evidence, or the evidence was conflicting or unreliable.
And in a criminal trial, if the prosecution fails to prove a key fact,
then the accused gets acquitted. Because the burden is on the prosecution to prove guilt beyond a reasonable doubt, if a key element is not proved, that burden hasn't been met. It doesn't necessarily mean the accused is innocent, just that their guilt wasn't sufficiently proven according to the law.
That's a really important distinction. Not proved isn't the same as disproved or innocent. It's about meeting the burden. Fascinating. So every single fact has to land in one of those three boxes.
Every single one, no limbo.
All right. Let's shift to the human element. Witnesses. When we think of court, we think of people testifying. Who can actually be a witness?
Generally speaking, almost anyone can be a witness. Section 124 of the BSA says all persons are competent unless the court thinks they're unable to understand the questions put to them or unable to give rational answers.
So it's about understanding and communicating, not about status.
Exactly. It could be due to very young age, extreme old age, disease, whether physical or mental. But even a person with a mental illness can be a competent witness if they can understand and answer rationally during, say, a lucid interval. Even young children can testify if the court is satisfied. They understand the questions and the importance of telling the truth.
Interesting. So what kinds of witnesses are there?
Well, there are several ways to categorize them. The most obvious is an eyewitness, someone who directly saw the event. They provide that direct evidence we talked about.
Okay.
Then you have expert witnesses, people with specialized knowledge, maybe a doctor, a forensic scientist, an engineer. They don't testify about what they saw happen, but they give their expert opinion based on the facts presented to them. That's covered in Section 39.
Right. Experts.
You might also hear about a hostile witness. This is someone who, when called by a party, seems to be deliberately not telling the truth or is antagonistic to the party who called them. The law, Section 143, actually allows the party who called them to cross-examine them, essentially challenge their testimony.
Ah, okay. What else?
There are chance witnesses, people who just happen to be there by coincidence, maybe a passerby who saw a traffic accident. There are interested witnesses, people who have some kind of stake in the outcome, maybe a relative of one of the parties. Their testimony isn't automatically dismissed, but courts usually look for corroboration.
Corroboration, other evidence backing them up.
Exactly. You also have official witnesses, like police officers or government officials, testifying about things they did in their official capacity. And finally, you have hearsay witnesses, though, as we said, their testimony about what someone else told them is usually inadmissible, barring those specific exceptions.
So lots of different types. And the court has to weigh their credibility, their potential biases.
Absolutely. The credibility and reliability of each witness is paramount. It's a very human part of the process.
Okay, so we've gathered all the evidence, oral, documentary, digital, direct, circumstantial. We've heard from witnesses. We've considered presumptions. What's the final step for the judge? How do they pull it all together?
That final, crucial stage is called the appreciation of evidence. It's the judge's job, or the jury's, where applicable to critically evaluate everything that's been presented.
Evaluate for what?
For its credibility, its reliability, and its probative value, basically. How convincing is it? How much weight should it be given? This is where they decide which facts have actually been proved, which have been disproved, and which remain not proved.
So what factors do they consider in this appreciation process?
Oh, quite a few. They look at the credibility of witnesses. How did they behave on the stand? Were their stories consistent? Did they seem impartial? Did they actually have a good opportunity to see or hear what they claim? How do they hold up under cross-examination?
Okay, witness credibility is big.
Huge. Then, the reliability of the evidence itself. Is this document authentic? Has this digital file been tampered with? Is the chain of custody for this physical exhibit clear? If it's expert evidence, were the scientific methods sound?
Right, the trustworthiness of the actual stuff.
Exactly. They assess the probative value. How relevant and significant is each piece? They look for corroboration. Do different pieces of evidence support each other? Does witness A's testimony match the forensic report?
Building that consistent picture.
Yes. They always keep in mind the burden and standard of proof. Has the party who needed to prove something actually met their required level, whether it's preponderance of probabilities or beyond reasonable doubt? They apply any relevant inferences and presumptions allowed by the law. And ultimately, they look at the overall consistency. Does the entire story presented by the evidence make logical sense? Sometimes, even the absence of evidence, something you'd expect to see but isn't there, can be significant.
So it's not just about counting pieces of evidence, is it? It's about the quality, the coherence, how it all fits together.
Absolutely. It's a deeply analytical and qualitative process. It requires careful judgment and reasoning to weigh everything fairly and reach a just conclusion based only on the evidence presented according to the rules.
We've really covered a lot of ground today, navigating the world of evidence under the new Bharatiya Sakshya Adhiniyam. From understanding what a fact even means in law, to seeing how digital evidence is now treated, the difference between direct and circumstantial proof. It's clear the law is this complex, evolving system for trying to find the truth.
It really is, and understanding these principles, even just the basics we've touched on, helps you appreciate just how rigorous that process aims to be. It's not just about what happened, but about what can be legally proved to have happened. There's a big difference sometimes.
Definitely. So next time you're reading about a court case, or maybe even just trying to figure out a complex situation in your own life, try thinking about it through this lens. What are the real facts in issue here? What are the relevant facts being put forward? And how reliable, how credible is the evidence supporting them?
It's a surprisingly useful way to think critically about information in any context, not just a courtroom.
A great final thought. Thanks for breaking that all down for us.
My pleasure.